From item number 7 to 18. Adjournment. 17, 7 to 18. 7 to 18.
May I please, your lordship. Lordship, I am appearing in item number 16, my lord. Here in this 16, my lord.
Yes.
Here in this case, my lord, respondents have filed their response, my lord. We want to file reply, my lord. Some time is required, my lord.
Have you informed the other side?
I have not informed, my lord. I will inform you.
Inform and then come on. Let the case be called out, you inform them, then we'll pass on this. Or you come when the case is called out.
Okay, my lord.
We'll adjourn, but the other side must be here.
Okay.
My lord, I beg to mention item 12, my lord, we have circulated a slip.
You have succeeded. All right.
Public.
My lord, I'm for the petitioner, my lord. My lord, can you date may be fixed? Okay.
Wait for 2 minutes, you'll get the date. 2 seconds.
28 July to 8. Any other request?
In respect of item number 1 of today's list, madam. Yesterday we have filed an additional affidavit. I pray, madam, to bring that affidavit on record, madam. It has been filed yesterday.
In item number 1, the review.
Madam. An additional affidavit has been filed, madam.
All right.
And so, like,
So when do you want it?
well, today itself.
Today. Let it be called out. Then we.
Lordship, we are appearing for R1 in this case.
All right. Mr. Advocate General is addressing us in this matter.
In this case, all the cases were disposed of by passing a speaking order yesterday.
Yeah.
That is what we have annexed in our additional affidavit. So we have extra copies also, we can furnish it also.
Furnished, we will take it up at 2 o'clock.
Lordship.
Any problem?
No, no.
I'm
Sir-
appearing for respondent number 1, my lord.
Send me copy on it.
My lord, F2, my lord, I have to go through all these things, my lord. I have to go all these things, my lord.
When do you want it?
Listen.
Consensus time.
Take care of my lord.
In that case, tomorrow, Lordship. In that case, no,
Only tomorrow.
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 We all-
Please serve most of them who are here. In fact, Mr. Chaudhary was representing most of the.
Respondent number 1, I am appearing.
Respondent number 1, and he was
I'm
representing
for 8 petitioners.
for 8.
I am only for respondent number 1.
Serve upon them
Yes,
the copy.
the Chaudhary is Mr. NND Chaudhary, Lordship.
All right, tomorrow is first case.
Lordship. Highly obliged.
And bring that affidavit also.
Yes, sir.
May I please, Lordship?
Yeah.
Pay for listing 1IA, Lordship. It was listed, Lordship, 23/3/2023, but not listed, Lordship.
All right,
Lordship, Friday, Lordship.
Friday.
Please, Lordship. Lordship, similar prayer for listing to read it, Lordship. It was filed last Monday and I'm praying for it to come on Friday, Lordship.
Those will be listed on Monday.
Lordship, I insist upon Friday, Lordship.
You insist for Friday or you request for Friday?
I request, Lordship.
All right, Friday.
Deeply.
Lordship, I have taken consent from the other side. Matter may be adjourned.
You've taken consent, so it's all right. Anyway, so this is item number
16, man.
16, as prayed for on behalf of the petitioner for the purposes of filing a rejoinder affidavit. And as agreed to by the learned counsel for the respondent. Let this matter come up for consideration after.
I'm highly obliged.
10th August.
This is about the 2 daughters. Just a minute, where is it? It's about 2 daughters from the second marriage.
Lordship, I am not aware about the facts of the
You're not aware, then how do you take time?
Man, I am appearing on behalf of NN Upaidhyay, my senior, my lord.
Oh,
I'm highly obliged.
yes,
Daily list for orders item 2.
straight. Notice 2 respondents. How many of them? All are state.
Then by the signing finance.
Who accepts notice?
2, 3, 4, and 6. I
2, 3, 4, and 6, you appear. Rest?
In the.
Mr. Borpujari accepted for respondent number 1 and 5.
Yes, Madam.
All right, notice to so and so, accepted by so and so. Affidavit, if need, if so deemed necessary, may be filed by the next date, re-notify and so and so.
24/7. Item 3.
Same.
Not saying. Why do we issue notice in this matter?
Because he has to wait with the order of the authority matter, whether they accept or not.
That's not a ground, but nonetheless, same order. So same lawyers will be accepting the notice.
24/7. Item 4.
Okay, delay of 788.
Notice to respond. You appear for respond number one.
For the performer, respond number 3.
For former respondents, we are not interested. Get respond.
For one.
Notice be issued to respond number one. Steps by both modes within 2 weeks. It's returnable August.
Obligatory.
14 August. For admission, item 5.
Yes, Mr.
Last order.
Yeah, we are aware of the last order. Tell us what is your. Now 5 months of, yes, Mr. Naik.
Yes, sir.
Yes,
Lordship, judgment that I was referring on the last date, Lordship, it's WA.
Mr. Naik, before that, would you like to hear the observation of the court? That it's an attempt to overreach the orders of the court. If you look at it from that angle, what is your response? Question is this. Now look at the court first, Mr. Naik. Mr. Naik, look at the court first.
Lordship,
Now, he was arrested,
Lordship,
correct?
Lord.
So invoking the provisions under 6(2), you suspended him. That suspension continued for 5 to 6 months.
Lordship.
He appeared before the court passed an order in line of Ajay
Kumar
Mukherjee or Ajay Chaudhary. And then his suspension was revoked. He was transferred to another place where that is a different location where the departmental proceeding is being continued. And then you invoke 6(1)(c) again.
Lordship.
What is the reason? Whether it is second suspension or first suspension or two distinct suspensions are two different things.
These are two distinct suspensions.
Correct.
Yes.
Even if you assume, then 5 months have passed by, you have not completed and he has an observation. Now, because he has chosen to challenge it, he has an observation in his favor that he would be entitled to approach the court for revocation of suspension again. If if the proceedings are not concluded within a reasonable period of time, and 5 months now, it was started long time ago.
That is not departmental proceeding, that is a criminal proceeding. Lordship, may kindly say 1C, 6(1)(c). This is criminal proceeding.
Correct, we have followed that. But if we look at it from the point, if optically it appears to be that this suspension order has been passed in order to overreach the order of the learned single judge.
No, Lordship. In fact, that liberty has already been granted by this honorable court in another petition. In that case, also, Lordship, I was appearing. This is WA 114/2000.
But now tell me when would the proceedings be concluded?
Lordship, that is a criminal proceeding, Lordship. That is not departmental proceeding. Second suspension, because
But
of.
why? But why? Now how is he going to tamper with the evidence?
Lordship, if Lordship permits me, Lordship.
You have not taken him to custody. You have not.
Now
So in that
he is
case-
on bail now.
He's on bail.
Yes.
So therefore, if he's on bail, why give him the subsistence allowance and not take work from him? Why? The
Lordship,
whole purpose stands defeated, no?
no, Lordship, permits me, Lordship.
Yes,
Lordship,
we-
may kindly see the dates for. Lordship.
Yes.
Facts. Lordship, he was arrested on 12/6/2024
Yes.
and he was released on bail on 27/2024.
27?
20/07/2024.
27.
No, Lordship, it's 20.
20.
Yeah.
Yes.
Order is 20, released on 27.
23. And the so.
Let him, Mr. Chaudhary, you hold back.
Yes, and so cause in the departmental proceeding was issued on 19/9/2024.
He was suspended when?
Suspended on order was issued on 18/6/2024, but it was, as it is a deemed suspension, Lordship, by implication of law. So his suspension was with effect from the date of arrest, that is 12/6/2024.
Correct.
Now, Lordship may kindly say, if plain reading, Lordship, if the suspension order was issued on 18/6/2024 and the so cause was issued on 19/9/2024, it is almost just 1 day delay, Lordship. 3 months. But there is another judgment, Lordship, that is passed by a court in learned single judge, Lordship. Therein, Lordship has said that period of 90 days will be counted from the date he was released on bail and intimated to the authority. Lordship, I kindly say he was on release on bail on 27/2024.
We appreciate that.
Lordship, I kindly say why these orders should not have been passed by the learned single judge at the first case, Lordship.
Can you argue that? Mr. Nayak, if you have not challenged that order, can you argue that?
I'm not challenging, Lordship. We have reinstated him.
Correct. So
Now,
now
subsequently,
can you
Lordship.
question the correctness of that order now? That's the whole question.
No, we are not
We are-
questioning.
we
We
are
are not
asking-
questioning. I'm just placing the facts, Lordship, nothing else.
No, Mr. Nayak, you have not responded to, we are ready to give you a hearing. You have not responded to our, what transpires from all this.
Lordship will just have one look in the order passed by the learned division bench, Lordship. In 114, one paragraph only, everything will be clear.
What you're going to say. Now, you just let us know by what time would you conclude the proceedings?
Lordship, there are 2 proceedings, Lordship. One is
We
departmental.
are asking about departmental proceeding.
Departmental, he was second suspension was not because of the departmental procedure.
We have followed that. We have followed that. You're referring to 6(1)(c).
Yes, so far as.
We understand that.
Lordship,
Otherwise, if it were not so, we would have dubbed it as a second suspension. And we would have hauled you up for saying that you have tried to overreach the orders of the court without challenging it.
that may not be correct, Lordship. Why it should not be correct, Lordship? Lordship will read that paragraph once, Lordship.
Mr. Nayak, try and understand what we are talking. We are not on different pages. We understand that. There is no, the learned single judge has made out that distinction. The order impugned here, which you are defending, is correct.
Lordship.
We are asking you, what is the rationale for suspending him when you have not done it for departmental proceeding? There it was necessary. You did not want to put him to the place where he was, where some demeanor was reported, or he was arrested in a criminal case. Now you want to keep him under suspension as long as the criminal case continues. Now, in that case, why Ajay Chaudhary would not be applicable proprio vigor with full force now in the second time?
Yes, it will be applicable.
So therefore, let his suspension be revoked again.
No. Why Lordship will not revoke?
No,
this,
you
Lordship?
can't answer
No,
that.
no, Lordship will
You have
just.
to give reasons.
No, I understand what your Lordship is asking, but Lordship will at least look at paragraph 17 of the judgment I am producing.
Where is that?
I have heard his copy.
See, there is no sympathy for an officer who is facing criminal prosecution, but then should he be treated to be a guilty before the criminal court passes the verdict?
No.
Should he be treated like that?
No, we are not.
Therefore,
Lordship
one,
punishment,
you
suspension,
started a departmental proceeding in contemplation. You continued that suspension as if it were a suspension under 6(1).
Lordship, so far.
Keep suspension. Mr. Nayak, you don't have to take a stand which is very rigid. Try and understand what the court is talking. We are not here to explain to you what is the position of law.
Lordship, it is rigid because Lordship will take, consider the allegation against him, Lordship.
Allegation is
He demanded and accept bribe from a person, Lordship.
correct.
That is the allegation. It's a very serious allegation.
Very serious. Nothing
And-
could be
and
more serious than
Charges are against him. So that is why I am pressing Lordship that paragraph 7.
Why then if that is so, do we, merely mere allegation would amount to, conviction? Now, what is the purpose? We may not we may not like to live the wheel. What is the purpose? But is it not vindictive?
No, Lordship, no. Lordship, just one paragraph. One paragraph.
All right.
W11.
How long do you, then you tell us, we don't see the logic. Then you tell us, we are giving you this leeway only for the reason that, that the officer is charged of bribe taking. So we don't want to give an impression that he deserves all the sympathy of the court. But then he has a right which he is invoking before this court. He says that if you continue the suspension as long as the criminal case continues, then it would be a very, very long time. And then Ajay Chaudhary comes into play. So could he not mold his relief in appeal? Though, of course, he has challenged. He says that both suspensions are not distinct, it is same. No, we don't agree with that. We don't agree with what Mr. Chaudhary has argued. But now, would you keep him under suspension till the time the criminal case continues, and you have no idea till what time will it continue?
Lordship, in terms of 6(1)(c), he can be suspended second time, subject to fulfillment of the conditions of Ajay Kumar Chaudhary.
And there will be no outer limit.
Outer limit, Lordship, if I am extending his service, suspension, after reviewing the suspension, suspension, then there is no question of applying Ajay Kumar Chaudhary, Lordship. Ajay Kumar Chaudhary, we are following, Lordship. In fact, Lordship, in terms of Ajay Kumar Chaudhary, there is a notification also that has been.
We will have our own. So tell us what is the expected time of conclusion on the criminal proceeding?
Lordship, I can say about the departmental proceeding. I can take that instruction also, or Lordship may direct us also to complete the departmental proceeding within a certain period. But so far as criminal proceeding is concerned, he is facing trial. And his second suspension only because of 6(1)(c), that is pendency of criminal trial.
You want us to record this?
Yes, Lord.
You want us to record this that
Well,
because there is a criminal case pending.
If Lordship.
Therefore, the suspension should be continued. If that is what you have understood, then we record it. If you want us to record this, we will record this. That this is the position of this is the ground taken by the learned additional advocate general.
Lordship may kindly see paragraph 17. What's Lordship?
Paragraph 17 where?
Of the judgment I have produced, Lordship. It's WA114 to 2022. It's a similar case, Lordship. Wherein also he was initially, suspended under Rule 6(2). Subsequently, court directed to reinstate him, Lordship. At the same time, court granted me this liberty, Lordship, at paragraph 17. Lordship may kindly see. For the reasons stated herein above, we hold that there is no merit in this appeal. However, since Rule 6(1)(a) of the Rules of 1964 permits the authorities to place an employee under suspension when a disciplinary proceeding against him is contemplated or is pending, or considering the fact that disciplinary proceeding has, in the meantime, has initiated.
That's the law. There's no other different disclosure of law than what is existing position. Correct. We agree to that. Now forget about the appeal. What is the ground taken in appeal? Now you say that you will continue with the suspension till the time, because this you have done. Ajay Chaudhary has been applied. Therefore, he has been reinstated. Please take yourself away from the slated position with which you have come. Now let us talk on a clean slate. Now with this position being explained, that this 6(1)(c) suspension is different than 6(2) deemed suspension. Somehow the other, it continued for a longer time than what it deserved. Now, this suspension, if you're asking us to ratify this as long as the criminal case continues, I don't think it's a good idea, and it's a good interpretation of law.
Lordship may kindly see 6(1)(c) once, Lordship. 6(1)(c).
We understand the powers under 6(1)(c). Are we disputing it?
Lordship.
We are not. This is what I'm telling you, no.
So what I'm submitting,
The
Lordship.
position in law is clear. The distinction is very well spelled out.
Lordship.
We have no difficulty in holding it. And we will not be treading a new path. It's something which has been decided. Now we are asking you another question. That with this suspension now, which is continuing for more than 5 months, now, would you like it to be co-terminus with the conclusion of criminal proceeding?
I'm not saying that. There is a provision of
If you're not saying that, then that's a good answer.
Yes, I'm not saying that. There is a provision of Rule 6(5), Lordship. Rule 6(5). Rule 6.5. An order of suspension made or deemed to have been made under this rule may at any time be revoked by the authority which made.
That's right. So
So that is the law.
when do we expect you to take this up?
Lordship, if the person, he has already filed one representation, Lordship, that has been disposed of by the authority rejecting his prayer. He will again file, Lordship. Why I am saying so, Lordship, at this stage, I am not seeing any reason why this honorable court will interfere.
That's not the way it is. That's not the way cooking crumbles. Anyway. Consider his representation afresh. He doesn't press this application on that ground. And then consider his application afresh. Why do you want to pay him without taking work from? Take
That
work
is
from.
a decision taken by the authority, Lordship. Justifying under the law, it is
That
permissible.
is the question.
This honorable court has also settled that he can be suspended second time. So that is what we have. Only
This suspension should, I mean, of course, you have rightly answered that this suspension need not be coterminous with the conclusion of the criminal proceeding.
Lordship.
Correct? So therefore, you decide. Take a call on that representation.
If Lordship permit, Lordship is, I mean, what my friend is indicating strict implementation of the direction passed in other commercial. That is one.
Implement, he's not asking that.
No,
He
if
says-
Lordship has already,
He says,
Yes.
therefore, he says that he, instead of asking for that benefit, he has challenged it, but he would settle for the revocation of suspension after a reasonable period of time. When there is no complaint of his, tampering with the evidence or trying to, unless you say that, well, we have serious doubts that in criminal case, he shall, if he's out of jail, you can't, he's on bail, you
I
can't.
mean,
say
that is the reason, Lordship, why the provision of 6.1c. That provision is there only because of that reason.
That reason is all right, but it cannot be coterminous, no?
No, I'm not saying it should be coterminous, Lordship. That is not my stand. I'm saying, Lordship, there is a provision of 6.1c. Initially, it was 6.2, now it is 6.1c.
You are coming back to the same thing. We have followed that. That is clear.
No, my
We
submission
are
would be,
understanding that was deemed suspension. This
Yes,
is for
yes.
the continuation of the criminal proceeding. But criminal proceeding, there is nothing is in sight. When would it be completed? Does he have a right to argue for suspension or revocation of his suspension?
Lordship, prolonged suspension, definitely maybe a good ground, Lord.
You are answering everything, but you are not.
But this is only 5 months, Lordship. 5 months is not a prolonged suspension, Lordship.
5 months is not.
No, Lordship.
When the earlier spell was also 5 months.
Lordship, only one judgment, that is Ajay Kumar Chaudhary, Lordship, who says, Lordship, within 3 months, you have to issue so cause notice. There is no other judgment. There is no other judgment. That is the only one judgment, Lordship.
Now, where is that rule here in Assam Service Discipline Appeal Rules? There are other state rules which says that if the criminal case or departmental proceeding is not initiated, the subsistence allowance would be hiked. Where is that?
That will be in the aforesaid, Lordship. If initially it is 50%, then it will be 75%.
Where is that provision? The wastage of public money. So we settle the law and we revoke the order of suspension. Direct for revocation. Otherwise, you are not taking the hint of the court. You should say that we will see, but 6 months his representation shall be asked for, and it shall be decided afresh in view of this.
That the Lordship definitely can pass that direction. Will definitely consider his representation, but it will be the decision of the authority.
When you leave it, we decide. Where you bring on record your representation having been rejected? Where is that? You'll see that.
We have not been informed about the presentation. Nothing more.
Bring it on record. Challenge that also along with this.
It was never, madam, never would communicate to us, madam.
You will record your statement that that representation has been rejected. We revoke the suspension. We say that it serves no purpose. Because there is no allegation of tampering with the evidence. It's not a question of, not accepting the order. The question is that there has to be a rationale. It can't go on indefinitely.
That is the law. No?
All right, we have heard. We have heard Mr. H.R. Chaudhary, learned senior counsel for the, learned senior advocate for the appellant, and Mr. P. Nayak, learned additional advocate general Sam for the respondent. Stage. The appellant, a senior district administrative assistant in the office of the district commissioner at Kacha, Assam, was arrested in connection with ACP police station case number 47 of 2024. He remained in jail for more than 48 hours. As such, he was suspended by invoking the provisions contained in Rule 6, bracket 2 of the Assam Services, bracket Discipline and Appeal Rules 1964. Hereinafter referred to as Rules of 1964. During the period of suspension, a departmental proceeding also was initiated against him, which, according to the information provided to this court, still continues. The appellant, in the meantime, approached this court seeking revocation of his suspension on grounds of delayed conclusion, on grounds of delay in conclusion of the departmental proceeding. The prayer of the appellant was allowed by a bench of this court in view of the judgment of the Supreme Court in Ajay Kumar Chaudhary versus Union of India and another, 2015, 7 SCC 291, and Rafed Ali Ahmad versus State of Assam and others, 2023, bracket 3 GLT 718. Pursuant to such an order passed by this court, referred to above, the appellant was reinstated on 9/6/2025. It appears that the criminal case against the appellant continued, and it is presently at the stage of trial. Next pack. Barely 6 months after the reinstatement of the appellant, he was again placed under suspension, and this time under the purported exercise of powers under Rule 61C of the Rules of 1964, which reads as hereunder. Which reads as hereunder. वो पूरा 6 से लेकर C and provided तक. The appellant questioned such order of suspension on the same being a second suspension with respect to the same case, which contention was not sustained by the learned single judge in WPC number so-and-so, holding that the earlier suspension was under Rule 6(2) of the Rules of 1964, whereas the latter suspension was under the provisions contained in Rule 61C of the 1964 rules. The aforementioned judgment of the learned single judge dated so-and-so is under challenge in the present appeal. We may also state here that while dismissing the case of the appellant, the learned single judge had observed that if in the second suspension of the appellant, continued beyond 90 days, he would have the liberty to approach the court again, questioning such continuance of suspension on the ground of rationality and reasonableness. By the present appeal, the appellant has questioned the judgment on two grounds, namely that the invocation of the provision under 6(1)(c) is nothing but a way to overreach the orders of the court in the first instance when the suspension order was revoked. And that there was no necessity of putting him under suspension when he had been transferred to a different location from the station where the departmental proceeding was continued. As on date, the departmental proceeding and the criminal case are continuing against the appellant. The issue raised before this court is whether the earlier deemed suspension, which continued for a long time and which was revoked by the intervention of this court, and the present suspension under purportedly under 6(1)(c) of the rules of 1964 are distinct. The answer to this poser is that these are two instances where suspension can be ordered. With the arrest and the appellant remaining in custody for more than 48 hours, he suffered deemed suspension. And during the period of this suspension, the departmental proceeding was initiated against him. Since it had continued for a long time, with no certainty as to the time when the departmental proceeding would be concluded, the suspension order was revoked by the order of this court. The appellant had been reinstated. The second suspension under 6(1)(c) of the rules of 1964 in this instance ostensibly is on the ground of pendency of a criminal offense under trial. This situation was present when the earlier suspension order continued. The departmental proceeding, along with the departmental proceeding, the criminal case also was instituted against him, in which he has been charge sheeted and now the case is under trial. So, under this suspension also, this suspension has also continued for more than 90 days. Under the aforenoted circumstances, we deem it appropriate to direct for revocation of his suspension and his reinstatement in the service. We say so for the following reasons. One, the departmental proceeding and the criminal case both are continued. There is no allegation of any tampering with the evidence in the tampering with the recording of evidence in the criminal case. There is no complaint of non-cooperation of the petitioner, of the appellant, in the departmental proceeding either. Semicolon. The appellant has been transferred to a different location. Considering these aspects of the matter, we have directed for revocation of the suspension of the appellant forthwith. Forthwith. However, it would be open for the authorities to invoke such provision in case it is found. We have also been informed that a representation filed on behalf of the appellant.
Lordship may not record that is on instruction.
So you should have agreed instead of getting all these
In
observations.
the meantime, Lordship.
You should have, this is what we are suggesting to you. In fact, we were more than clear in suggesting to you that you should have said that, well, keep this under hold. Let the representation filed by the appellant to be decided afresh. Could you not have said that?
I stated that.
No, you did not.
I said if representation is submitted.
As an order holding your action to be bad and holding your action to be non-rational. We don't want to do this in the first instance, but then we gave you sufficient hint, did we not? Did we not give you that hint?
I
Mr.
made
Nayak?
submission, Lordship. Lordship has passed this order. Lordship will pass.
This is what you should have said. Anyway, we will. Anyway, that's it. You're defending your client, that is all right. But then we told you that take a recall. We are agreeable to that legal point, that you have the authority to suspend it. But then going by the observation of the learned single judge, this time for 90 days, I don't think it is advisable to continue the suspension indefinitely. Yes, take that. What have you said? We have also, you don't have any idea. We should not record this. That his representation has been rejected.
In the second case, Doctor. Yes. So far as the second suspension is concerned, whether any representation is there or not, that instruction.
Anyway, उसके बाद वो जो हम पहले लिखा था वो बताओ. However, the authority shall be at liberty to invoke the provisions contained under 6(1)(c) if it is found that the appellant is not cooperating in the departmental proceeding, or for that matter, trying to deflect the course of justice in the criminal case. In the criminal case. With the aforenoted direction, the appeal stands dismissed.
Obliged for.
Item 6.
Yes.
May I please, your lordship? My lord, in fact, my lord, when we go by the order impugned, my lord, it appears to be a consenting order, my lord. My lord, may be pleased to turn to page 108, Annex 2 is the starting of the order, my lord. The facts of the case, my lord, regarding an election tribunal, my lord, election petition matter pending before the learned tribunal. And the learned tribunal, my lord, passed an order, my lord, summoning the ballot papers and the records for the purpose of, my lord, future records that it can be counted or whatever it has not been decided. Now, my lord, that order, my lord, constitute to be an interim order, and that had been put into challenge before the learned single judge. And my lord, relying on some of the, my lord, judgments of this, my lord, honorable court as well as the honorable apex court, constitute to be an interim order. And therefore, my lord, the order of the learned tribunal had been interfered with. My lord, in fact, concession had been.
Mr. Boyan, you have shown us the paragraph 10. This had escaped our attention.
My lord.
How can you challenge it now?
My lord, now the challenge is that, my lord,
We were about to set aside this order. We were about to set aside this order that the references taken by the learned single judge to the case of Urbi Bora and Tajul Islam is different. Now, how could the matter have been resolved by the tribunal without asking for a recounting?
Exactly, my lord.
So therefore, if you concede there, you don't ask us to review the order.
my lord,
You can go before that court for review and.
no, my lord, my very limited, my lord, respectful submission before
I'm
my lord is there, my lord.
very happy, Mr. Boyan, that you have shown us this. It had completely escaped our.
No, my lord, no, my lord, I
No,
cannot.
it had escaped our attention.
No, my lord.
Good you pointed out.
My lord,
Otherwise, we would have set aside this order after issuing notice to the other side.
no, my lord, I
And
cannot.
you would have also stayed the operation of this order. Because there is no other way in which the allegation can be decided. If the tribunal is in ceasing of the matter,
My lord,
who is to decide whether the calculation was inappropriate or it was reversed for some reason or the other?
only the ballot papers are the source, my lord.
Correct, but why did you concede then?
My lord, some miscommunication or something may be there. My lord, we have find out few judgments, my lord. My lord, we have find out few judgments.
Then in that case, we'll have to issue notice and we'll
My
say anything.
My lord, my lord.
Why did you concede?
My lord, it was not about,
You had a right
Right.
to argue.
my lord,
You did an order.
my lord.
Take it. We have heard Mr. A.R. Boyan, learned senior advocate for the appellant. And Mr. S. Barua, learned counsel for respondents numbers. One. Correspondent number one. This appeal has been filed against the judgment dated 28/4/2026, passed by a learned single judge of this court in WPC number 162 of 2026. Next. The dispute originates from a panchayat election held in Golpara district, Assam, for the post of ward member
My lord.
of unit number 8 under Simla Bari Gaon Panchayat. Next. The appellant was a contesting candidate along with the writ petitioner has been along with
Respondent five is told, I am the told.
respondent number 5.
Five.
After the polling on 7/5/2025, the counting began on 11/5/2025. The results had been formally declared on 12/5/2025, holding respondent number 5 to have been returned successful. The appellant raised serious doubts on the counting of the ballots, as during the initial counting round, he was winning by a large margin. However, the tables turned only after a few hours, and respondent number 5 was declared the winner with 365 votes, compared to appellant having polled 294 votes only. The contention of the appellant before the authorities was that this could have happened because of wrong preparation of the counting chart, where votes cast in his favor were wrongly recorded in the name of respondent number 5. And next, an election petition by miscellaneous election petition number 1 of 2025 was filed by the appellant before the district judge from Panchayat Election Tribunal Golpara, seeking recounting of votes and a declaration that the election of respondent number 5 be held to be invalid. Next, the election tribunal passed an interim order on 23/12/2025, directing the district commissioner Golpara to produce the ballot papers in sealed trunks before the tribunal to enable recounting. Aggrieved by this direction, the respondent number 5 approached this court by WPC number 162 of 2026. Challenging such interim order as being impermissible. It was urged by respondent number 5 before the learned single judge that such an interim order could not have been passed by the tribunal, as the election petition was yet to be finally heard. He also referred to the cases of Purvi Gora Das versus Srimati Kiran Saitya and others, decided by the Gauhati High Court in WPC number 6309 of 2016, and a decision of this court in Taijul Islam versus Inamul Hussain and others in WPC number 4026 of 2035. Based on these two decisions, the learned single judge set aside the interim order passed by the election tribunal and but clarified that the proceedings before the tribunal shall go ahead and the issue shall be decided in accordance with law. This conclusion has been questioned by the appellant on the ground that recounting of votes was the only way to decide the matter at hand and to ascertain whether the result of the election was correct. Without preserving the ballot papers and its recounting, no decision could have been arrived at by the tribunal. The interim order passed by the tribunal, it has been argued, was the only way in which the issue could have been finally decided. The objection from the perusal of the order, we find that the objection raised on behalf of respondent number 5 was illusory, inasmuch as only for the conclusion of the proceedings in the tribunal, such an interim order was passed, which would not have in any other way affected the prospect of the parties or would have changed the nature of the proceedings before the tribunal. This would only have facilitated the process of decision making by the tribunal. The reference of the two cases, the reliance on the two cases referred to by respondent number 5, it has been argued, was misplaced, as in those cases, the effect of an interim order was to the effect of the interim order was to restrain a party from taking oath as a member of the, as a member to the body to which he was elected. Let notice be issued to respond number 5 on steps being taken by the petitioner, by the appellant within a period of 1 week. Both modes returnable on August 1st, July. In the meantime, Mr. Barua also shall give him his response to the memo of the The ballot papers shall be preserved in the meanwhile, and the tribunal shall not pass a final order till the next day.
27 July.
Highly deeply obliged, my lord.
Item 7.
Yes.
The husband of the petitioner number 1 had expired in a motor vehicle accident. Hit by a tractor. And there is a government notification dated 15/11/2004.
You see. Ms. Bordoloi,
Yes,
can you apprise this court? Have we decided in division bench?
that Manisha Khatun.
No, our judge.
Manisha, no?
Manisha Khatun did the
Manisha has been taken note of this.
not yet.
But that subsequent notification subsequent to Monisha was put to challenge that I think we have passed some order or some observation.
There's a vague memory that we have done that.
There is another case, Your Lordship, alia, Lordship, that day the petitioner was absent, that was posted in August, Your Lordship. That is not in this. Same case, Your Lordship, like
What do
this.
you have to say to this?
Lordship, it is very clear, Your Lordship, the Honorable Justice Surana Singh's order, Your Lordship, Manisha Khatun. It is detailed, Your Lordship, it is discussed in detail when they are getting the MSCT compensation, Your Lordship, and here the weightage is also identified. It's not a hit and run case, Your Lordship.
You have a difficult case, Mr. Counsel. The difficulty is notwithstanding the sympathy, the only thing is that this MSCT proceedings will take time.
Yeah.
And in that case, now can we do one thing, that ex gratia payment which will be deducted finally? Because here the offending vehicle was known. A case also has been registered.
That is the
Talking to her.
subsequent notification.
Oh, please hold
My
on.
case is, my case is prior to.
We are arguing for you. Don't strain yourself so much. Can you find out? Mr. Advocate General, I think your assistance in this would be necessary. With respect to ex gratia payment, I'm sorry, we are asking you offhand.
No.
But because you are the first law officer of the state.
No difficulty.
And this is with respect to policy of the state, therefore we want you to clarify. Now, there was a policy long time back that for any death, though basically it was directed towards, terror, but it also included in it accident. Later it was modified. It was modified and said that if there is an accident on a public place by a public vehicle, then. But there have been some decisions and there is possibly a policy which says that in such a situation, ex gratia payment can be made subject to the vehicle remaining unidentified.
Hit and run.
In that case, MSCT would not be able to do, or insurance would not be able to be asked for payment. Third party risk or whatever.
Common parlance, we call it a hit and run case.
Insurance,
Lordship.
perhaps nothing gets paid.
Lordship.
So in that case, whether it can be done. Now we are asking you a different question altogether. MSCT takes a lot of time. Here the father, in this case, the parents are also they were all dependent on him. And he died because a speeding tractor dashed him. That has been identified, case has been done, but MSCT will take a long time. So ex gratia payment of 2 lakhs would have bailed them of the difficulties, and MSCT would have taken into account that this ex gratia has been given. Now, these are two distinct things, but that could also be removed. Is there any policy of the state? Because there are, in some states, this is the policy. Ex gratia payment, and then when the matter is being decided, that shall be deducted. Just to.
I'll look into it, but as far as I know, Lordship, only for the hit and run cases.
Yes.
Where the vehicle is not there, in that cases we are giving, initially it was 25,000.
We are not asking you to make any amends. We just asked you whether, because MSCT will take time.
The MSCT also have an interim compensation within 3 months.
Interim compensation. So then nothing.
Within 3 months, that interim amount has to be given. If it earlier it was, as per the old schedule, it was 50,000 for one and 1 lakh for one category. Injury.
You are Mr. Teka. And we can't help. Go before that. That sense of urgency also. There
Is
a
taken care of by the MSCT Act.
We can't help.
Some cases are pending 20 years, 30 years maybe. It is open up to the Honorable
You go
Supreme Court.
before the MSCT and say that you want an interim compensation.
No.
They don't interfere with this. Take it.
But some persons are getting especially after.
We are very sorry. It's very difficult for us, for such families to be shut out from the relief, but we can't go beyond. We can't go beyond our remit.
That is the violation of Article 14.
Don't argue that.
Still getting compensation. Same similar method.
Don't argue.
Even in Mauritius case, during the pendency of the appeal, the relief was granted. And Lordship-
That is why the whole policy of the central government is that there should be a third party insurance. If the vehicle may not have a comprehensive insurance, but third party is mandatory.
As per Honorable Justice Ujjwal Bhuya,
We were really looking at it from a.
Because it will have a very big ramification financially in the state. Very big.
Correct, we understand that. We don't cross our limits in that.
Mr. Advocate General, but it's still being paid, as he has said, that cannot be negative.
Yes,
Even
that negative equality cannot be applied there.
But you should ensure that, because
But under the provision of the welfare scheme,
No, we can't ask. We can't issue a mandamus. Sorry.
No.
Sorry, Mr.
Lordship,
Decker.
as per the Honorable Justice Ujjwal Bhuyan Court,
Don't take the name of the judge. Just say a judge of Supreme Court.
I'm sorry, Lordship. Justice. Ex gratia, therefore, ex gratia payment would mean a payment made by the authority beyond any
What is the
legal.
distinction between ex gratia and this? This
Yes,
ex gratia is not.
It is a payment which is unconnected with and unrelated to a legal
That is the
obligation
reason.
passed on.
Mr. Teka, try and understand. That is the reason what is preventing us from even passing that order. That give ex gratia and deduct it from the MSCT compensation. We can't do that. These are two different things. So you go before the MSCT, ask for an interim compensation. We can't help it.
So in the notification, no.
Anyway, we have said all that. We could have made you understand, but then good efforts by you. We have heard Mr. R. Dekar, learned advocate for the appellant, and we write her name only.
Lordship.
And Miss N. Bordolal, learned standing counsel, Revenue Department. The appellants who are the wife and the children of late Dhanjit Das have questioned the judgment dated 10/2/2026 passed by a learned single judge of this court in WPC number 6979 of 2021, whereby the claim of the appellants for being paid ex gratia relief on account of late Dhanjit Das having died in a road accident in the year 2019 has been rejected. It appears that the accident took place on November 27, 2019 on a public road in the district of Buxa. Late Mr. Das was hit by a speeding tractor from behind, as a result of which he died instantaneously, which fact was confirmed in the post-mortem report. The family of late Dhanjit Das / appellants sought relief of ex gratia payment of rupees 2 lakhs on the strength of a 2014 government notification, which allowed for grant of such ex gratia payments in cases of accidents in public places or by public carriers. When the authorities did not accede to such a request, the appellants preferred the writ petition. Referred to above, which was rejected. The learned single judge, by referring to the judgment of this court passed in Monisha Khatun alias Monisha Khatun in WPC number 2700 of 2023, held that in the present case, since the offending vehicle was not unidentified and a case has already been registered, which will be examined by the MACT, the appellants, there is no occasion for the court to direct for grant of any ex gratia relief. The reason for we while going through the judgment were only contemplating whether the proceedings in the MACT would be time taking and whether any payment of ex gratia relief would bail out the family from a sudden crisis of the bread earner dying in that accident. However, considering the fact that under the MACT, under the Motor Vehicles Act, there is a provision for entering relief to the aggrieved party, we only conclude this appeal by suggesting to the appellant to approach the tribunal for interim relief in case so deemed necessary.
That is no fault liability for death. It is under the new, this 5 lakh rupees. No fault liability don't have to prove. It is given.
Where a bigger amount than what is demanded by the appellant could be granted to him under the no fault liability. The appeal stands disposed of with the opinion of the doctor.
Deeply operated.
Item 8.
This one is against the order of CAT at page 246. Notice was not issued an earlier occasion.
Mike,
Against the order of CAT, which is at page 246.
now what's wrong in the order?
My lord, the wrong is that, my lord, the Megachandan judgment is not at all applicable in this fact situation of this case.
No. Were you born in the cadre?
My lord, my contention is that my seniority and promotion improved relying on the Railway Board circular of 2012. That Railway Board circulars are put to challenge before the CAT Hyderabad then. And CAT
That is not in
Please,
existence.
the Hyderabad CAT's order confirmed by the Supreme Court, these are different issues altogether. We are asking your questions.
Yes. Yes.
Now,
My
you
lord,
want- you
yeah.
want the seniority to be reckoned from the date of vacancy.
No. When matter is. No,
We have put a question in a very narrow
Yes.
compass. Say yes or no.
No.
In that case, we issue notice.
No. Not from the date of vacancy.
Then
My lord,
but you were not born in the cadre. That the problem could be with the railways. They sent you for training later. Is that correct?
yes.
So therefore, it will be counted from the date when you. Of course, the order passed by the tribunal is very cryptic.
Cryptic.
But the order being cryptic. Like notice the issue. Who appears for the railways?
From respondent number 1 to 5.
You are appearing.
My lord.
Yes, you tell us.
But first thing is that,
You respond. This is a very cryptic order. We don't get to know many facts. You do one thing, you respond to this writ petition. Mr. G. Pegu, London Central Government Council, accepts notice on behalf of respondents number 1 to 5 and submits that counter affidavit in this matter shall be filed by the next date. Mr. Wali. The appellants were directly recruited. The appellants are the directly recruited commercial apprentices to the RRB against 15% direct recruitment quota. They had joined the service in higher pre-revised 5th CPC scale of 500 to 9,000. Their seniority was fixed by a list dated 1/4/2012, which was not in dispute. However, later, after the 6th CPC merged the scales into grade pay of 4,200, the Railway Board issued a circular which was later clarified. And on the strength of such clarified circular, a revised seniority list was taken out on 4/6/2015, where the petitioners have been placed juniors. They have been placed below their juniors, some of whom who had not even appeared in the limited departmental competition examination 10% quota. The petitioners were also downgraded to the post of chief commercial clerk from the post of chief vigilance inspectors and commercial superintendents, and were denied the grade pay of 4,600 initially, which was granted later. So the tribunal has ratified such a revised seniority list on the ground that the petitioners were never born in the cadre, and therefore they could not have claimed seniority from the date of issuance of vacancy. The aforementioned factual position is being disputed by Mr. Nath, learned counsel for the petition. Let the affidavit let counter affidavit on behalf of response number 1 to 5 be filed positively by the next date, re-notified so and so. August 10th.
Notice to the private respondents.
Private respondents are also there. Let notice also be issued to response number so and so on steps being taken by the
6 to 10.
6 to 8 within a period of
10.
जो भी है, within a period of 2 weeks, both modes returnable last August.
24/8. Item 9.
What is the stage of the SLP?
Not yet decided, not yet for similar, this order in another petition.
We'll pass the same order here. You are Mr. D.N. Sharma.
Yes, my lord.
We adjourn it for August. Let's see what the Supreme Court says.
August.
As prayed for on behalf of the petitioner, Union of India, let this matter come up for consideration on your date in August. Now let it be decided by Supreme Court, and then we'll take a call. And we don't say that, otherwise it used to be a direction or something.
28/8. 28/8.
28.
Item 10.
Yes, Ms. Sharma.
Well, things, I have received instruction from the deputy.
Why don't you receive instructions? This is compliance of section 14.
Lordship, yesterday, second half, we have received an affidavit in opposition from respondent number 3, Lordship.
That's the superintendent of police.
That's what has he said.
He said they have not received any instruction or order from DC.
The reason, my lord, I'll place from your lordship's
Take
brief.
instruction.
Well, kindly see if I may most humbly draw your lordship's brief attention to page 28 of your lordship's brief. Well, the annexure 2, which has been translated, does not contain a main line, my lord. Appearing in page 2. They have not given me, my lord, kindly see, that's very crucial. The holder of the secure, they have not filed the affidavit.
Provide a fresh copy of the brief along with the annexure. She'll get back.
They have not filed the affidavit, the instructions that I have from the deputy commissioner under section 14. This is their sheet anchor, my lord. Page 28 of your lordship's brief is the sheet anchor that's been wrongly transcribed. It does not contain the last line. Well, that is glaring and deliberately, my lord. They have not filed their affidavit from the face of it under section 14. And they're insisting that they want possession.
Yes. Sumitra Sharma, government advocate seek some time to take instructions in the interest and report back to this court. In the meantime, they are not saying anything. File a fresh.
I'll file, Lord. I'll file.
With all the annexures which are readable, which are legible.
Lordship. Highly obliged.
Yeah, date is August 1st.
12 August.
Highly obliged, Lord.
Item 11.
He's a dismissed CRPF constable. Where, my lord, the charges against the petitioner is that it is a second menace. And for that, the departmental proceeding is under that the bigamy charge, second article. First article is that he tampered the I card. During the inquiry, he produced his original I card. And it is a personal affairs from the complainant is a lady who may not, they are arising from the personal affairs. Now the conclusion of the learned single judge without the giving any conclusion that the marriage was 494 of the IPC attractive, so that the Rule 15 can be utilized.
Mr. Nath, you think we will go into that? That it was a live-in relationship and then there was no definite proof of marriage with
Exactly.
Neelpati Singha.
Yes, yes,
You are a person of very dubious.
my lord. That is, but the charges to be proved.
As a constable, we can't keep you.
My
We
lord,
can't interfere
four-
with it.
four
It's
nine-
not shocking to the judicial concerns that you have been dismissed from service.
My lord, 494 to be proved,
Look at this. You are a constable.
my lord.
You tell you who would have benefited by that admit card, by that service identity card, where you have projected yourself as Devashish Singha.
Hmm.
And even the first marriage, she says that she has married you, she has filed a criminal case. That criminal case ends in discharge because of a technical ground. And then you go and marry another lady in a temple. And there also you say that I'm a CRPF.
No.
Assuming that every allegation.
Other ladies' education is not taken.
Why did you not now we go on one charge only? Why did you not inform the authorities that there is a criminal case against you?
My lord, that is a affair. I was not in custody. Only affair. I was not in custody. And though no
You were
penalty.
arrested.
Now isn't it?
You were not arrested.
No.
You took bail.
Yes.
Anticipated.
I was not in custody. So question my
Why
lord.
we are not?
Only my
We
lord,
are not getting persuaded even to issue notice.
my lord, my only submission is that my lord, whether 494 without proving the 494
In a
the
departmental-
procedure of law. Can
Mr.
be-
Nath, tell us one thing. In the departmental proceedings, such probe would be made that this was only, there was no saptipadi, there was no marriage, there was no proper marriage according to
No, my lord, rule 15 of the CRPF rule says there must be bigamy. And bigamy to be proved, 494 to be proved.
Assuming every allegation, it's not advisable for you to be kept in service.
My lord, it is my disproportionate ground also not looking.
Not at all
My
disproportionate.
lord, that
What could be,
my
what could
family-
be lesser punishment?
no, my family is also my lord this and this my lord.
Which family?
My lord,
Which family? You're not sure which.
no, I was,
woman you have married.
No, my lord, I married by in the disciplinary proceeding, I have said that I married only one legally. And she is now
The
staying,
second lady in your life, who is the first?
no, the first is the complainant, claiming that first I am complaining. Complainant claimed
The
her.
second one, some
No.
other lady, what is her name?
Yes,
No, who is the second person with whom you have contracted marriage?
my lord, I was at the, by, yes,
El Nanita Singha is the early one, Prembati Singha.
yes,
So Prembati Singha has not filed a case against you.
no.
उसको भी due-
She is my lord, the petitioner has.
Who would have made that identity card?
My lord, I have not made. I have stayed independent. There is no proof.
Very
I
well. And photograph is of yours.
No, she has stated. in the
Photograph
inquiry-
आपकी है.
My lord, she has stated in the inquiry at page 66. Page. She has categorically stated.
We can't expect the domestic proceeding to go like a criminal trial and find out all.
Because charges of forgery.
According to who's your pastor?
Yes, no way.
My lord, my lord, the lordship has rightly said that there is a live-in relation. Live-in relation does not mean it is a wife. Wife to be established for the charge to attack under Rule 15.
Mr. Nath, you're a colorful person, we agree, but then we can't keep you in service.
My lord, my humble submission is that until and 494 is proved, then Rule 15, how they can apply to charge a bigamy. Marriage to be proved, marriage was not proved. Then 494 will not attract, then Rule 15 cannot be approved. He has committed mistake. My lord, I am relying on a Supreme Court judgment on bigamy. 1960.
What Supreme Court?
Bigamy.
No, bigamy we are not looking at.
494 to be proved. That otherwise,
Criminal case
how it
नहीं
will be
है.
proved?
This is not a criminal case.
No, no, then my lord, how, if bigamy is not proved, then how rule 15 will attract? Rule 15 specifically says, during the lifetime of a legally married wife. I have married.
Now, if we let you in, or if we give you some space, you'll dupe another woman. What is the justification? Who would have made that identity card with your photograph and a different name? Who would have benefited from that? I mean, we are not able to understand this. You're talking about bigamy. You're talking about proof of the fact of your first marriage. We understand all that, but who would have benefited? We ask a simple question to ourselves. Who would have benefited?
See, during the
And if you have done that, whether you have married Neelabati Singh or not, you had kept her in live-in relationship on the projection that you are Devashish Singh. And this is your photograph. You are a CRPF constable. Who made it then? And you expect the departmental proceeding, and you expect the court to direct the departmental proceeding to get into that. Who made it? And increase the ambit of the entire, departmental proceeding. Is there a criminal court?
No, there must be prima facie
Prima facie satisfaction.
That I
That a lady comes before the authority, and she has deposed also.
Yes.
She's
She
one
has
of the witnesses.
deposed that she took the colour photograph.
She says before the authority, before the departmental proceeding, that this is the identity card that he gave to me, and I agreed to live with him. Then he married me in temple, and then I have learned that he has married another lady. And then therefore 3 charges were leveled against him. One of making that forced thing, one of marrying one lady and marrying another during the subsistence. A criminal case may decide, okay, you have been discharged. On what ground have you been discharged?
Technically.
On what technically?
My lord, I have enthused in the order.
Now what is that? Tell us.
I have enthused the order, Lordship.
आप बताएं ना. अब वो पढ़ूंगा नहीं, आप बताइए.
That is the revision was not, the charge was prior to framing of.
When were you dismissed?
My lord,
When were you dismissed?
2014.
Wait.
I
What have you been doing up till now?
My lord, is a security agency is working the security guard.
Be happy. Be happy with your present sign. Sorry. We have heard Mr. S. Nath, learned advocate for the appellant. And Mr. UK Goswami, learned this.
My lord, page 67, I only point out one thing, page 67. Only this is the question answering of this lady, the affixing of the I-card.
Yes, let us give you complete hearing. Otherwise, you'll charge the court that
My lord, sorry.
you have made our impression only because of your colorful personality. Huh?
My lord.
Say,
Page 67.
page 67.
My lord, there is a question put to her. From where you got the photo of Ujjwal Singh?
Which is the question?
Page 67. Of the daily order.
Question number 17.
17. From where you got the Ujjwal Singh for affixing I-card issued by the GP? When Ujjwal Singh gave me the CRPF I-card, then he gave me one copy of the photo also. So my humble submission is there. Her allegation that I inserted a color photograph.
Mr. Goswami, though he is not argued, but we must put in our, anxiety also. Could it not be a ploy of the first lady to put him in trouble? Is this not a retaliatory action? It's a photocopy. There is no forensic analysis. Now, can you take away the service of a person on this ground?
In fact,
It is not shocking to our conscience. I mean, we would not reduce the penalty or we would not do anything. But whether this aspect can be completely ignored. Now look at this. Now, it is all based on the complaint of this Neelabati Singh. And Neelabati is agreed.
Nandita Singh.
Huh?
L. Nandita Singh.
Sorry, Neelabati. L. Nandita. L. Nandita Singh. L. Nandita Singh is aggrieved. She is not happy with him. Either he has refused to marry her or has married her and trying to show. So she would have produced this.
Otherwise also, why?
No, but who has done this?
No lady come to
No, this is
making allegation against the appellant. Definitely he has done something.
Anyway, and where is that? How has it come to how the departmental authority has come to a finding that this was made by him? He denies it. So it's an oath against an oath, or not even an oath against an oath. It's an allegation and a counter allegation. Has he made out any case that it was deliberately prepared by somebody? Did you make out that case?
No, I denied. I have not made.
Anyway, you respond. Let us give him one more opportunity to prove his bona fides.
Mild, deeply aggressive.
Take it. We can't come to your rescue.
Even that it is a dismissal from.
Because you have been dismissed from service, we'll give you one more opportunity. Today we also appear to be fixated at one point that you need to be dismissed. The next day, maybe we'll look at it from a different point of view.
Mild, because it is after all dismissal from.
The appellant has been dismissed from service of Constable General Duty, CRPF. 3 charges were leveled against him in a departmental proceeding, namely of his having made and used a fake service identity card. Roman 2, contracting a second marriage without permission and without divorcing the first wife, namely L. Nandita Singha, in violation of CRPF rules. And failing to inform the department about the criminal case registered against him by L. Nandita Singha. The records reveal that L. Nandita Singha made a complaint that the appellant has married another lady called Devabati Singha.
Premabati.
Which Pati?
Premabati.
Devabati Singha. During the subsistence of his marriage with her, she agreed to marry her. She agreed to marry the appellant after being satisfied that he was employed in CRPF as a constable, and he disclosed his name as Devashish Singha. She was lent assurance, she was given assurance of the identity of the appellant by a service identity card of the appellant, on which there was a photograph of the appellant, and his name was described as Devashish Singh and not Ujjal Singh. Mr. Nath, learned advocate, in the departmental proceeding, the charges were found to be proved, and the appellant was dismissed from service. He appealed against the aforenoted dismissal, which too was dismissed. The learned single judge affirmed the order of dismissal by the disciplinary authority and approved of the order of the appellate authority, affirming the punishment of dismissal. Mr. Nath, learned advocate for the appellant, has submitted that the departmental authority, that the disciplinary authority did not take into account that there was no marriage between the appellant and L. Nandita Singha, and that there had been no forensic examination of the photo identity card of the service identity card. He has further raised the issue that the complaint was a retaliatory move of L. Nandita Singha, with whom the appellant had never married, the criminal case lost against the appellant ended in discharge, let notice be issued to the respondents. Notice is accepted by Mr. U.K. Goswami, learned CGC, who shall respond to this memo field by the next date, we notify August. We'll come back
August.
after 5 minutes.
Item 13.
Yes. Madam. Disability pension.
May please your lordship. I'm appearing as a legal aid counsel in this matter. In this matter, we are challenging the order passed by the Honorable Central Administrative Tribunal, Gauhati, whereby the petitioner has been disallowed disability pension. His father was serving in the railways, and after the retirement of the father, he was getting his pension. Subsequently, the mother was getting the family pension. The mother expired in August 2019. Subsequent to that, we filed an application before the NF Railway that we should be granted, the petitioner should be granted disability pension because he had suffered locomotor disability. Along with the representation, the medical documents were also provided, the disability certificate, etc. The disability certificate categorically shows that yes, he's suffering from 43% locomotor disability. Initially, in 2019, when the OA was filed, only the 2019 certificate was available, and at that point of time, the disability was temporary in nature, 43%, because of certain improvements. Prior to that, AIMS had declared him to be a permanently disabled person. There were improvements, so GMCH issued the disability certificate saying that it is temporary disability of 43%. Later, this disability certificate is valid only for a period of 5 years.
Let us see Rule 75, under which you asked for that pension, disability pension.
Lordship, I do not.
Now, how do you expect the court to say? We are inclined, we are in a doubt. The tribunal says that your disability should be at the time of grant.
Yes.
That is at the
Yes,
time of death of your mother.
And the
Just a minute. At the time of death of your mother.
Lordship,
There are some doubts. We'll see what Rule 75 says, because that only grants you the right to seek pension, disability pension being a ward of a railway employee. Correct. Now there is another aspect which has been relied upon by the tribunal. It says that it is not merely your disability
Yes,
or the percentage of disability, your
It is
earnability. Whether you can
livelihood.
earn.
Livelihood. That is the main issue.
That is not a fact which has to be decided completely. It has to be to the satisfaction of the pension paying authority. Correct. So therefore, in all its fairness, if this is the argument which you want to raise, then you must show Rule 75 to us, no?
I will, Lordship, but before that, if I may just be permitted to show one medical board finding of the
That is
railways.
not required, no. The medical board, you may get any medical board certificate. What we are concerned with.
Not mine, Lordship.
So 43% disability.
No, Lordship. Now it is no longer 40.
Now, therefore the question, no. Now, why do we go beyond the disability, certified by the medical board at the time when the pension should have been granted?
Admitted.
I think a reading of section 75 would make it very clear. Otherwise, this cannot happen. Sometimes late in the life, you develop some disability. Now, would you be entitled to go before the authorities and say that my father worked with you? I have developed this disability, therefore give me pension. Can that be done? Can you think of that situation? We are not talking about immediate hardship to you. The moment you say that you have a locomotor disability and then you use crutches and you have weakness in legs, that is all right. But when did it happen? Now, has it to be continuous?
Lordship, that is what I am trying to show to your lordship. If your lordship kindly sees the finding of the learned tribunal at page
Are we
133.
Are we to decide? We are not sitting here as medical board, are we?
On at
One
page
second.
133.
Railway Service Rule 75. Now, otherwise, this can be extended to a different situation. We don't want to twist the law to the advantage or disadvantage of either parties.
Indeed, lordship.
So therefore, suppose I give you a fact situation. While asking you, while putting this question to you, we are also reframing
Yes.
our thoughts. Suppose X dies. He is an employee of the railway. His wife gets the pension. She dies. And the son is all right. He doesn't work for some other reason. Some disability, but he can earn. Mental, cognitive faculties are absolutely okay. He doesn't work, so he doesn't work, he doesn't earn. Later in life, his disease is aggravated. I'm giving you a fact situation which is similar to yours. Just a minute. Later in life, his disease is aggravated. Can he come back to the railways and say that now that I've become very ill, I can't earn, please give me pension?
I am not at all on the aggravation. I will not even press on the 2024 disability certificate whereby it says that it is permanent disability. I will restrain myself only to the extent what was his position on the date of the death of his mother.
That if you want to show, you can.
Yes, lordship. That is the only thing that I want to show to your lordships. If your lordships kindly takes page number 133. 133. It is a part of the impugned judgment.
Observation.
I will just show two things and which will be off at that point of time. Page 133, lordship, paragraph 13, if I may read. The applicant was having temporary disability of 43% and not suffering from permanent disability on the crucial date of death of his mother, that is on 9/8/2019. So this finding is already there. My extent of challenge to the instant order is only to the second portion. That is the issue regarding whether the medical board was right in deciding that the applicant is able to earn his livelihood. Now, lordship, if I may kindly take your lordships to page number 112 for a moment.
112, yes.
112. Lordship will kindly see history of present illness. The patient had sustained injury on his right hip following a road traffic accident on 23/10/2005. He was admitted at Sanjeevani Hospital, Gauhati, and treated for fracture neck of right femur, closed reduction, and osteosynthesis with cannulated cancellous screw was done on 24/10/2005. Later, when the operative site got infected, he consulted orthopedic surgeon in a private hospital at Patna and underwent removal of cannulated screw with debridgement of wound on 14/1/2006. But the patient continued to experience pain in right hip, discharge from wound, and had difficulty in movement. Subsequently, he consulted orthopedic surgeon at AIIMS New Delhi and was diagnosed as a case of non-union of fracture right neck femur with ankylosis of right hip joint. He underwent right total hip replacement on 12/4/2008 at AIIMS New Delhi. On follow-up at AIIMS, he was found to have infection of wound and completed anti-tubercular treatment in April 2021. Now, lordship, I will leave the last line also because that is subsequent to the death of the mother.
Please come to page 113. We have read that.
Yes, lordship. I am coming to page 113. Opinion.
A bit faster in reading, so therefore
Yes,
we have
lordship.
crossed over. So
Opinion.
please read page 113. Come to the discussion part and the second paragraph.
Yes, lordship. The discussion. If I may
The second
just
paragraph.
though he has difficulty in walking, he is ambulatory with support of crutches. even though he has 50% permanent disability in relation to his right lower limb, there is no other disability including intellectual disability. His present disability will not deprive him from performing any sedentary job. There is also provision for government jobs for such disability if eligible.
Under the,
Now,
under the,
Lordship, prior to
the
that,
PWD Act.
Lordship, if I may just show one more point. There is one finding of the medical board itself where it says that there is constant discharge from his wound.
Yes.
There is constant discharge from his wound.
We
Lordship.
see that. We see.
So, Lordship, even if we take the date to be not 2026, we take it to be 2019.
No, the other, we are on a different aspect altogether. These are the facts that he can say. Earnability, was there section 75? That's maybe. You have the rules. See, the argument is this. This doesn't impress us. This doesn't impress us. The question is that whether a medical board is competent to talk about the earnability. And even if it does, whether there has to be a complete satisfaction of the authorities or independent assessment. That is one aspect on which the case would hinge. Otherwise, prima facie, we don't find any fault with the tribunal's order. But if a person is entitled for it, he or she must get it. If not, we are not going to use our sympathies. So that only section 75 will tell us. You
Now,
should have
Lordship, there are notifications. If your
You
Lordship,
should have quoted rule 75. That's the primary section under which you are entitled
I will
as a son.
Lordship, there is, if your Lordship kindly sees page 81 formally.
No, without the rules, we will not be able to appreciate your.
Lordship, then I will not waste the precious time of
That's
this
what
honorable
I'm
court
saying.
since the rules are not available right now.
Bring the rules.
Yes, Lordship. On internet also, I could not find it. Otherwise, I would have mailed it. Lordship, if it
The petitioner suffers from a serious locomotor disability affecting his mobility in the lower limbs. Stop. He has been suffering such disability for decades. He is ambulatory only with the help of crutches. The issue before this court is whether 43% permanent disability in lower limb would entitle the petitioner to seek pension from the railways, where his father was employed, and after his death, pension was being given to the mother, who also unfortunately died recently. The tribunal before which the matter was taken to held that the medical board clearly spelled out the range of disability and also suggested that such disability would not come in the way of the petitioner in performing any sedentary job. So based on such medical report and observation by the medical board, compensation was refused to be paid to the petitioner by the railway. The tribunal concluded that the satisfaction of the authorities was necessary, not only with respect to the disability, but the capacity of the person claiming such privilege, claiming such compensation, claiming such pension to earn his livelihood, and whether such satisfaction was to be based on an opinion by the medical board. Rule 75 of the Railway Service Rules entitles a ward of an employee to be paid pension on the death of the employee in case of disability which prevents him from earning his livelihood. The provision contained in rules have neither been quoted in the petition nor has it been discussed in the impugned order. Let the order, the learned advocates for the parties submit that the rules in question shall be brought on record by the next day. Re-notify on after 2 weeks.
If it could be on 10th Lordship.
If it could be on
10th Lordship.
10th, I don't think 10th would be. Next week, 10th would be too early. They can give you a date sometimes on 25th or 2nd.
What? 25th. Yeah, too.
If I'm keeping on behalf of Party Board, instruction is not received. So one for this time.
You're using a telegraphic language, instruction not received. Now what do we do if instruction is not received?
1 4 weeks time.
Huh?
1 4 weeks time.
You want 4 weeks time. Now how can a change be there when by a government notification, when the Parent Act has done away with the salary limit? That's the question. And you need to answer that. What instructions would your client give you? Now, this is an argument which you have to develop on your own. They are not going to do it. They have come out with a notification. Anyway, who leads you in this matter?
Party Board.
It's not again. We will ask the AG to assess them. The learned AG is here. Can we ask him to come? See. Mr. Advocate General, the general practice is that the Advocate General gets the primacy in hearing, number one. Now, if the Advocate General is sitting in the courtroom number one, it is the duty of the court number one to ask him which matter brings him here. Number one, because he would be needed in other courts. Number two, the Advocate General has to sit in front. Many times it's very, what should I say? It was very fortuitous that I saw you sitting there.
It is not
You
because
don't
of
sit in the-
I was doing some research, that's why.
All right. But normally an Advocate General should sit in front so that he
Yeah,
is the line of gaze of the court. Many a times you will be requiring your assistance.
Lots.
Now, here is a case where you would be required to address this court. Now, this is with respect to the salary ceiling limit of Provident Fund scheme for the tea gardens. Initially, it was 15,000 was the salary. That provision was removed from the Parent Act by way of an amendment. Later, by government notification, it has been restored. The question is, can it be done by a government notification? It can again be done by amending the Parent Act. That's the question. So he came with a telegraphic answer, instruction not received. So I said that this is
a purely legal question.
What instructions? You have to develop your argument. So, Mr. Advocate General, we will request you to address us.
No difficulty at all.
We are not recording that the Advocate General has been interested. Or do we record?
No, Lordship, maybe so that my name will.
Yes.
So that I can come.
Correct.
But normally, Lordship, by executive order, it cannot be done.
Yes. This is an Therefore, the requirement of AG in some of the matters where we call upon you. The other law officers will not say this because there is a government engagement.
I'm obliged now.
Okay, they. The Assam Cha Karmachari Sangh, a registered trade union under the Trade Unions Act 1926, representing the workers, mainly in the tea gardens in Assam, has come up before this court, challenging a notification dated 12/11/2024, issued by the Labour Welfare Department, Government of Assam. Next. The Assam Tea Plantations Provident Fund and Pension Fund and Deposit Linked Insurance Fund Scheme Act 1955 was enacted to provide social security benefits, particularly Provident Fund and pension, to workers employed in tea gardens and related establishments in the state of Assam. The Act defines employee and mandates the framing of a scheme for compulsory provident fund contributions. Initially, the definition of employee had a salary ceiling, which was increased to rupees 15,000 per month from 2016. Notwithstanding this, most of the tea gardens, notwithstanding this, most of the tea gardens continued contributing provident fund on actual wages without strictly enforcing the ceiling. Some tea gardens tried to limit the contributions after 2016 to align with the limit, but it fell in litigation. With this background, the state of Assam, the government of Assam amended the act and removed the salary ceiling entirely from the definition of the employee. This meant that all workers, irrespective of their salary, would be covered under the act and would be entitled to provident fund benefits on their full wages. Despite this amendment in the year 2023, the impugned notification dated 12/11/2024 referred to above has been issued, which amends the 1968 scheme. By way of this notification, a provision has been inserted that even if an employee's monthly salary exceeds rupees 15,000, the employer's contribution to the provident fund would be calculated only on rupees 50,000. The petitioner has urged before this court that this notification effectively reimposes a salary ceiling, which had been removed by the competent legislature way back in the year 2023. So the notification defeats the purpose of 2023 amendment. And in fact, it contradicts, it is in contravention of the Parent Act. The question before us therefore is whether a subordinate legislation by way of notification bringing amendment in the scheme under the act can override the provisions of the parent act. We have requested learned advocate general to assist us in the fact. Let this case come up for consideration on sometimes in August.
There's an interim order that will be extended till today.
What is the interim order we have given?
They are getting the pensions are deducted as per the old system on social wages.
No, हम तो interim order
Last
नहीं है, क्या नहीं?
22nd of February 2025.
और पीछे
Until further order, so it is a open order. Lord.
Order.
interim order in the meanwhile shall continue.
21-8.
Normally, this court does not pass an interim order in legislation. Anyway, we will continue.
There is a delegated power is there. I'll very examine lot.
Item 15.
Appearing on behalf of DSGI, my lord, the instruction not yet received, my lord. To file affidavit.
Oh, Mr. Nath, you have accepted the lower post. You have accepted the lower post, haven't you?
Yes, yes.
Then why do you question?
My lord, I am entitled for, I have been,
So you shouldn't have accepted. You should have said that let me be an assistant loco pilot.
that my lord, my appointment was given after 2 years. That too after filing of the RTA application. And they have been, my lord,
They say that you don't,
unemployed, there
they
is
say
a,
that you don't have the qualification.
unemployed, it has no bargaining power.
We understand. We'll not read it against you.
Right.
Normally, in other cases, in departmental promotion and all that, if we accept it, and if such acceptance is not under protest,
Yes.
we don't allow it to be appealed. But we can understand. Question here can be really, it doesn't have to be qualified.
Another thing really hard, my lord, is like in fairness of Mr.
DSGI will appear.
Mr. Parasat, but we had given you time on the last occasion, no? You had said that Mr. RKD Chaudhary had appeared and he said that he'll be filing response affidavit. We want a clear affidavit, whether the advertisement was, all the posts were vacant for assistant loco pilot, and whether he had the qualification. Don't give a roundabout answer in your affidavit. Say whether he had the qualification or not. That he has accepted a lower post is something else. And not all posts which you advertised were of ALP, I'm sure.
No, not at all. According to the my qualification criteria, posts are distributed.
And they say that you have done it from some center of excellence, therefore it is not equivalent to
That
IPL.
they have clarified, the railway board has clarified that this is equivalent.
No. What is required for ALP?
ALP, that is electrical COP, here they conduct the course, it is equivalent to ITI. And their clarification is it is ITI electrical.
But how tribunal says that you do not have the.
That's the problem. Tribunal did not went to the merit of the case. And
Tribunal says in so many words that you are not entitled.
that is what, that all without traversing those documents where the railway board has clarified, this qualification is accepted as ITI. There is nothing, I have entered all this.
The persons who have been given ALP post, they have fared better than you.
No, their reply before the tribunal was that the ALP post was not given because he's an electrical, ITI electrical.
No. Look at this. Now you need to answer this before we will ask him. Otherwise, let the response come. Paragraph 9 of the impugn order. Page 133. Says that as per the notification, ITI electrical, which is equivalent, you are the holder of an equivalent degree.
Yes.
So ITI electrical is required qualification for only one post, which is category 13, technician grade 3, diesel electrical. ITI is not a required qualification for other technical posts or also for ALP, and as such, the applicants were not selected for the post.
Yes, that is a wrong. That I will show my lord RRB notification. Notification is saying that ITI, these are this / or there is electrical also. That has been wrongly quoted here. And apart from that, my lord, my reply, that is this Railway Recruitment Board also clarified that electrical trade ITI is an accepted qualification for the post of ALP, published in CEN 01/2014, page 114. This has not been taken care of in the tribunal.
And you had applied against the post.
ALP. ALP. I have been adjusted, I have been given the appointment in the lower court. Financially also some my lord, lower. And beneficially also lower.
It's not required for other. Equivalence. We are not on equivalence, Mr. Parasha. Don't come with your response on equivalence of the degree. Whether according to notification, your notification is vague. Anyway, Mr. K.K. Parasha. Learned advocate for the respondent, submits that the response affidavit shall positively be filed by the next date. Re-notify August. Yes, September. You're in job, therefore we are not in a.
Yes, sir. No.
Let him take.
No.
24/8. Item 72/23.
In this case, SOP is ready, we have to just notify. In fact, it was already circulated, but not in public domain, but all the officers were responsible.
Prayer to Manta now.
Yes, ma'am.
That SOP should be there.
Yes, SOP was issued already, but it was not notified. But very detailed SOP by considering the various direction of National Green Tribunal as well as the recommendation of Justice BP Kotoki's commission.
You have brought it on record.
Yeah, I'll bring it out to the record.
We'll close this. All these matters are unnecessarily.
So far as my lord, this PIL is concerned, my lord, it is okay. My lord, others, my lord, probably some other issues is there.
Other issues are what?
I don't know, my lord.
May it please your lordship.
Well, the other matters relate to mining by Coal India in total violation of the central government's law.
Then that would be a.
And there's an interim order to the effect, and your lordship is monitoring that case. So what I pray, the Assam government has taken the recommendation of Justice Kotoki's. He went into the entire issue, and the short point is that he made an indictment that there were massive illegalities. So there's an interim order of the Honorable Division Bench on 33/2023, where the court says everything has to be stalled. No more mining.
No more rat hole mining.
No. Our matter was not on rat hole. our matter was in violation of the 1980 Act.
So no mining by Coal India now.
No, they have stopped it. Legal mining is there. Illegal because they broke.
Possible.
Well, in fact, the central government has said that the state government and the Coal India Limited, where did they get the authority?
They are mining legally as on date.
That-
It's not that absolutely that mining is closed.
No, my lord, your lordship, if
Where
your
is that
lordship takes
interim
the
order?
order, division bench is order.
Generally, you look into all this.
Because this is,
Yes.
yes,
Well, what-
I will handle this matter.
Mala, what I want to say, the Assam government has taken the matter very seriously and has appointed, the chief secretary has appointed a monitoring committee in 2023, taking into consideration the recommendation of the Justice Kotoki's report.
And what happened to Anamika Hazarika?
That is under extension only. Maybe another 1 month is left.
So,
In the month of July, it is left.
so now,
So my prayer is that since it's a case of continuous mandamus, the monitoring committee may give its quarterly report to this court. They have given one report, they gave a report late. And the division bench was about to issue contempt.
Mr. Das, we would not continue with such monitoring. But if we are satisfied that things are being done, monitoring committees there, we'll not keep it in our hands. But we will ensure that it happens. On the next date, you please handle and take unnecessary handling.
But the lordships.
We'll give you liberty to revive this petition in case you find that it is not being done.
Because this continuing mandamus has come from England, where the court's monitoring is protecting the
As
environment.
we know, England, we don't take
No,
notice of.
no, Malak, I
But
won't say.
Vineet Sharan's case, Vineet Sharan was Hawala Khan. was
Yes,
the first case.
Vineet Narayan.
Vineet Narayan is the first case where we
Yes.
toyed with the idea of continued
Continuing
mandamus.
mandamus. But in the environmental field, the
We
entire
have-
world knows that the
But we'll
judges
do-
made law in India is the law.
Mr. Das will ensure that things don't go haywire.
Yes. Malak,
And we give you the liberty to have it reopened on a 2 pages affidavit. So that's the way we have been handling these
The
cases.
lordship will protect us.
Yes, and then the passage to you to come back to us, not with a voluminous petition, but a 5 pages affidavit that this is not being done. So that the old petition will be revived. But we'll not keep it on board. We'll not keep it on board on the next date. Mr. Advocate General, you please look into all the matters. Give us a different slot for each of the cases. SOP thing, Mr. Mohanda's case is well taken care of. SOP with the notification of SOP, I think you'll not be, you would not have anything else to say. But this rat hole mining should stop.
It has already taken care of, Lordship. The district committee, monitoring committees are there.
But till the SOP comes, your lordship will keep the.
We will, yes, yeah, till the SOP is before.
SOP is already there, but
But that
we will
SOP
notify
That SOP would cover the case of Mr. Das also, no?
everyone's.
Yes,
Lordship.
everyone.
Because in every district, we are considering district mining control committee.
Give a copy to
Yes.
them also.
I'll
And then you
right.
tell us whether we should close this or not.
Yes, sir. I'll make my submission on the next.
But not for
No,
lingering
no,
this
no,
matter.
not. As per lordship says, only we want.
We will give you that passage.
Yes.
We'll give you that. What happened? All persons were given 10 lakhs rupees.
That one, yes, Lordship. All bodies were recovered,
All 9.
all 9. We engage all the persons, Lordship.
All right, SOP you would like to see
Lordship.
as prayed for. As prayed for on behalf of these respondents. Let all these matters be listed after 1 week, 2 weeks.
2 weeks, Lordship.
Was we are in.
Before the vacation, Lordship.
After 2 weeks, mandate. We will close this with the SOP, and if it satisfies, with the liberty to all of you to revive this petition.
Because there were one thing I forgot, Lordship. In some matters, we had challenges the lease which were extended. But leases were extended till 2030-35. PL 39, 29. Well, those matters,
Mr. Nath, you are here assisting
well,
Mr.
those
Now
matters
you do
cannot
one
be
thing.
closed.
Make a note of the prayer in all such writ petitions separately. We are not saddling the learned advocate general with this task. He will bring the SOP on record, but you do that exercise.
Because 29.
Mr. Das can do that as the lead counsel in all the matter.
Yes.
You do that,
Because-
we are asking you. Let the other advocates also not object to your handling the matter. Let you tell us the prayer in
Yes,
each of the writ
those
petitions.
matters need not be closed because leases were challenged
Okay.
and central government supported my case.
Those we will not.
Yes.
Those we will not.
Maybe make a note of this.
Yes. We will distinguish and segregate.
But primary thing I thought was publication of SOP.
Yes. It is in force for last 1 year. Yes.
Okay, but has not been notified.
Has not, but the concerned authorities are given
And some
But
provision
for public consumption. It has to be noted.
penal action in case of any
Violation.
violation.
I'll look into that also. That. But
As prayed for.
22-6.
Okay.
That too. You have any
Not-
other matter here?
the next matter is that medical college.
Okay.
Sorry, Aero City, airport case, yes,
Okay.
case.
4-30.
Kati?
Item number 27 and 29, Lordship, 2 IA has been filed.
Hmm.
Basically, what we have raised here is that there is ongoing change of the nature and character of the land because their art filling is going on. When we actually gave in the boundary and demarcated the thing with some tin sheet barricades, this honorable court was directed not to do that. So a order was passed to that effect. Now they are changing the character. The matter is sub judice. In fact, it was already acquired, assessed, and award has also been given. There is no flaw, but they have challenged the act of 1964.
Where is the timing?
One is 1670 and one is 1671. WBC 230.
1671.
Lordship. Paragraph 5, Lordship. Paragraph 4, the order which was passed against us, Lordship, that is in paragraph 4 and paragraph 5, and we have also annexed the photographs. How the development of the plot of land is going on now. Page 10. These are recent things. If you look at the color of the bricks also,
In that petition. No, all right.
and the other case also, there are three photographs. Major trading.
Each interim order was in which, I think, earlier interim order.
That they shall not be dispossessed.
Dispossessed.
Where is that order?
Order detail.
In which petition? In which appeal?
It was in Hollister only.
WPC 6172
WC 6.
and 239. In those cases, orders of.
Yes, Mr. Chaudhary.
In fact, our instruction is we have not done anything.
So we'll say that.
Status.
So we allow this IA.
Yes.
We allow the IA when the matter is to be heard.
We want there is some urgency because public interest is being affected.
Date.
Let it be after the vacation.
The first week of August.
Yes.
Have you fixed any date in the matter?
No.
Also, could it be in the last week of July, Lordship?
Last week of
Maybe 27, 28. Because overall project is being.
Correct. Therefore, we have asked, but how come we have not fixed a date in every matter, no petition is left undated. How come no date has been given?
28 and 9, I had some difficulty, maybe 2, 3 days earlier or later.
Yes, Mr. Advocate General.
Yes, 23rd in that case, Lordship.
23rd.
23rd.
Order maybe. Export procedure खाली एक निकाल के दे.
আমার একটু কথা আমরা দেখি
Can you just show us that order of
I
law?
was just finding that.
We are not getting that order.
Yes, 21/1/26. If your lordship could kindly have a look at IA 251 of 26, in writ petition 239 of 26. That order was passed in that IA. Order it says in such time.
Just show me the order.
21st of January 26. In writ petition 239 of 26.
The first order is 3/11/2025.
Oh, yes, that
Isn't
is
it?
311.
3/11.
Yeah.
Thereafter, you allege that they have violated and
Therefore, that order is that 239. WPC
This 3/11/25 order.
For the
311/25 is there.
no. There is an order authored by us.
Yes.
That is in IA.
IA.
For so far,
No,
it
no,
is
no.
into violation.
No. In WPC 239 of 26 on 21/1/26.
230.
239. Order dated 21st of January.
इसको ठीक से रखना फिर. सब इधर उधर हो गया.
11.
Both the IAs, namely bracket में IA number 1670, 1671 of 2026 have been taken up together. They have heard the learned Advocate General and Mr. Ken Chaudhary, learned senior advocate for the parties. Several writ petitions were filed challenging the validity of Assam Land bracket requisition and acquisition bracket close Act 1964. On several grounds. As an interim measure, this court had directed that the petitioners should not be dispossessed from their should not be dispossessed till the pendency, till the decision in such matters. At one point of time, this court had also directed the respondents to remove the tin sheet boundary. Today, both the applications have been filed, both the interlocutory applications have been filed with a grievance that the petitioners have not been dispossessed, but they have attempted to change the character of the land by coming up with new constructions. The prayer made in the interlocutory applications are therefore to restrain the petitioners from changing the nature of the land. Though the petitioners / respondents in the interlocutory application have denied of having changed the character of the land, but considering the fact that the issue that the respondent state has been directed not to dispossess the writ petitioners, till the time the issue is decided by this court, comma, we make such direction absolute with restraint on the writ petitioners also of not changing the character of the land in any manner whatsoever, failing which this court would take serious view of the matter. Failing which this court would take serious view of the matter. In all fitness of things, the writ petitions ought to be decided at the earliest. Keeping that in mind, we direct for listing of all the writ petitions on 23rd of July.
23rd of July.
We give a time also on 23rd of July from 2 p.m. at 2 p.m.
Lots.
23rd of July at 2 p.m. Both the interlocutory applications are allowed to the extent indicated.
Highly obliged.
Meanwhile, we'll file our rejoinder.
Correct. We'll make your pleadings complete. We will. Yeah.
Item 31.
Back to you.
Yes.
My lord, the matter pertains to custodial debt of the petitioner's son.
Matter pertains to.
Custodial debt of the petitioner's son, my lord.
Huh.
My lord, he was picked up from North Lakhimpur in connection with Hajo PS case number 193 under section 302, my lord. Now, my lord, the police authorities say that while interrogating him, he named another two accused who were purportedly hiding in Udalguri district.
First order. Show us the first order. Just we will look at. Please give us 2 minutes.
The first order is 7/4/2022.
What is this? Where? Award compensation for the custodial debts. When did he die?
My lord, as per the FIR 3/12/2021.
And what is the any inquiry, any inquest?
Yes, one judicial inquiry and two inquiries, my lord, one by a judicial magistrate. and
Report of
another
that inquiry?
by- Report of the.
Who
inquiry.
appears, Mr. Nath? What is the status?
In our affidavit, we have annexed both the reports. We have filed the affidavit on 21/4/2023.
What have you said?
The inquiry reports we have annexed. And in fact, the affidavit in opposition, first affidavit we have filed and we have in detail, we have said he died by drowning.
He died by
Drowning.
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 Huh.
In fact,
Drowning where? He was in police custody.
he was in custody, but while kindly permit me to take your lordship to the affidavit. The postmortem report is
Postmortem report says
Your affidavit dated?
cause of death due to asphyxia, due to drowning, antemortem drowning.
So how did he drown himself?
lordship, the facts and
You must have put him, I mean, the state authorities would have put him in the water.
No, yeah, actually.
They are in your custody, no?
It was in custody, but while they were on their way for a search, for making a search,
Right.
Wait, kindly come to the
No, let us see the report.
report.
Page.
Yes. So report is available at page number 90.
Page?
Page 90.
90.
This is the report of the 176 CRPC. Judicial. Affidavit filed by Hitesh Chandra Roy, SP, on 21/4/2023.
Page 90 is an ordered sheet of JMFC Raju.
That's true. That is the report. That is the report. 7/7/2023.
has been handling this matter?
This matter is coming up in the before the division bench.
What special legal?
Special debate.
Special. Read that part of the report which you want us to believe.
Matter. Well, the Lordship, I'll take your Lordship. Well, the details report, the procedure of inquiry is recorded at page number 91. Mala. Kindly come to page 93. All the statements of the family members have been recorded. Then the opinion of the medical officer is important. At page 93 bottom, witness number 14 had conducted the postmortem report and he had opined in the first instance that the injuries present over the body of the deceased were antemortem and were caused by blunt force impact. On the same day, when he came to depose before this court, he stated that the final report is pending and hence he could not comment on the cause of the death of the deceased. Opinion of the medical officer on receipt of the final post.
All right, we have followed my opinion and the findings thereon. Please read it.
True. My opinion and finding. From bare perusal of the statement of all the witnesses, it appears that there was no foul play on the part of the IO or the other officers, office bearers, or any other person in the death of the affair named accused Sanful Ali. It has been seen that the statements of the witnesses that Sanful Ali was a habitual offender and he was involved with many cases. There is corroboration in the deposition of the team led by Additional SP Amin Gao, Additional SP Gwalior, then SDPO Romia. Witness number 13, Rasmi Pratap, has deposed that she conducted the inquest from 9 a.m. to 10:30 a.m. at Tolaram Patna Civil Hospital while the dead body was kept inside ambulance. And as per the inquest report submitted by her, death of the accused was caused by drowning. And thus she mentioned that cause of death is by drowning in the inquest report. I went through the inquest report and found that there is corroboration in the context of the inquest report and the statement of witness number 13. Witness number 14, Mr. Asim Teron had conducted a detailed postmortem examination of the deceased when he opined that injuries present over the body are antemortem and caused by blunt force impact.
No, how postmortem is all right, but witnesses must have been examined, no?
Yes, Pala.
Which witness says what?
Well, the report of the
read from the details of the report submitted by the IU.
Yes.
Page 90.
Yes. Well, I have the record of the
as I was on maternity.
As I was on maternity come childcare leave till
this is the IU.
No, this is the one of the judicial magistrate JMFC first class. As I was maternity leave come childcare leave till 3/1/2022 on 3/12/2021. Mr. So-and-so was in charge of Hajo Court. That is the Court of Judicial Magistrate Hajo. And on the same day, the IO had submitted a report to the PSI Court Hajo in reference to Hajo PS 119 so-and-so under section so-and-so stating that on 2/12/2021, the FIR named accused Sanful Ali, aged about 28 years, son of so-and-so, resident of so-and-so, was apprehended in the early hours under North Lakhimpur Police Station, Lakhimpur District, along with two accused, Muhammad Ismail Ali and Kusum, and alias Kusum and Muhammad Nazrul alias Hurumoni. It was also informed that the accused Sanful was kept in Baihata Chareli Police Station and North Gauhati PS and the co-accused person were kept at Kamalpur PS as detaining them at Hajo PS would have led to a law and order situation at Hajo. And on 2/12/2021, on interrogation, Sanful Ali declared arrest at North Gauhati PS at 8 p.m. It was also informed that on interrogation of the accused Sanful Ali at North Gauhati PS, the accused informed them that the remaining absconding accused persons, namely Laden and Bola, may be hiding at Koiroveri and other nearby locations of Udalguri district, and thus it was decided that a raid would be conducted at Udalguri district along with the accused Sanful Ali, and that the police party moved towards Udalguri from North Gauhati at late night hours so that the raid could be carried out before sunrise. And accordingly as planned, IO along with the additional SP headquarters Kamrup and staff took the accused from North Gauhati PS and proceeded towards Udalguri via Mandakata Road. And after traveling around 15-20 minutes.
Let's see the postmortem. That story that's a stock story which is there in every case of as lawyers we have done that.
Postmortem report they have annexed in the writ petition. In the writ petition, page number 46. Annexes 6.
Page 46, my lord.
Page 46 in the writ petition.
Observation at page.
External appearance, kindly, my lord. First column, external appearance. Condition of subject stout. But there, lordship will see a male dead body of average build and swarthy complexion is found on trolley wearing a black so and so. Mud particles are found inside the nostrils, mouth, face cloth, and other parts of the body are placed. Face is congested, blood stain, and cloth is present over the left side of the forehead. Body is warm internally, bluish discoloration of nail bed is seen. Rigor mortis is present. So this is
Suppose the story is believed
Mark.
of the IO.
Mark.
Then he ran for easing himself, and then he pushed the policeman and entered a water body. Now, if that were the case, then there should not have been any laceration or contusion all over his body.
But
Used operation. Because it's not a hilly, nothing. It's not a river which flows through, rocks. There it can happen.
look, some little bit of
It's not little bit.
little bit of bruises make
Laceration,
while
skin deep on the left side of forehead, contusion measuring so and so, contusion measuring. And what makes the doctor say that it is death by asphyxia?
yes, kindly come to page 47, below. Coaps. Mucosa congested, sand particles found adherent to the mucosa. Then right lung. But in case of drowning, this mud particles and other particles will be inside the lung.
No, agreed. So therefore there was congestion.
Yes.
There was congestion and not free flow of air in the breathing space. But how to explain contusions and aberration?
But what I would submit, my lord, those are not the cause for death, my lord. Those are not fatal, my lord. Ultimately, he died because of asphyxia.
That argument is misplaced, Mr. Nath. That may not be fatal, but these are evidence of the fact that he was put to death.
Look, he was.
I mean, there would not have been any intention of killing him, but you've killed him by beating him.
No, I would submit.
These situations we are aware of.
No, but
You're talking to a judge who has handled so many custodial death matters as lawyer and judge.
No, it is my duty to place before your lordship, Lord. Ultimately, in case of a drowning death, what would be the position of the body and the postmortem report, and what would be the position?
Now, if you ask for that, then we can get deeper. But it will be a case of 302 for the police officer in whose custody the man was there.
But it may not be. Kindly.
Don't get into. Let us not get into some deeper aspect. In fact, the state have done better by giving compensation, notwithstanding the cause.
But he's in custody. That's true. That's true.
Everything is read against you. And what was the offense?
Offense was
302.
Offense was murder.
Murder.
Offense was.
And how was he a history sheeter?
No, my lord, there is no conviction on that. But there is in the report everywhere says he is a hardcore criminal. From where they come to the
Criminal antecedent is there. Criminal antecedent is there.
All the more reason why police wanted to get rid of it.
No. That may not be the case. Kindly
that we can't say that we don't have any materials to say that, but this is the most logical inference.
Kindly appreciate one.
Or the police officer did not understand that this would cause death. Every time I have read this, this is the regular defense. Like in dowry death cases, the regular defense is that she was the stove burst. I don't know which stuff I'm talking about. Why does it burst only in case of daughter-in-law? Why not daughters? Why not other members of the family? Who believes all this? Every time, I have handled many such cases. The regular defense is that the deceased was arrested from his village. We were taking him to the police station. He was sitting in the jeep with no handcuffs. Then he tried to jump down the jeep, fell down. We brought him to the hospital. And the postmortem says that the spleen was fractured. Now, fall from the jeep will not cause fracture. Bursting of the spleen. That is only when somebody hits him at that place by his leg or something.
But in a case of
I mean,
that,
who would believe all this?
in a case of that, and then body
You
is
know,
cut down.
custodial death can put you, I mean, death sentence also would be less. Because here, somebody is in your captivity. And if you kill him, there are chances where people die without there being any intention. One slap and the person dies.
Maybe there may be case. Only but
And then you created a difference, no?
no,
But and all that. Who explains the aberration? Suppose what is the whole system? I mean, somebody, if a person is produced before a magistrate, he's supposed to look at him and ask, "Have you any complaint against the police?" We don't leave him alive for him to ask for. Aberration has to be explained. You could have said that at the time of arrest he tried to run away. The mild force was used. This could have been explained. But because you are guilty, you have a guilty mind. You don't look at that. You only think of putting the blame on the person concerned that he drowned. Water body, which water body? Where? Was that a river, a big river, Brahmaputra?
No, it's not a big river.
It was in the
It's a river.
What is the month?
December, winter, there is no rain. And Lordship, the judicial officer has given some photographs. Lordship will kindly look. The child cannot drown in that time.
Where is the photograph?
Judicial officer in this, along with his report, he has given some photographs of the place.
How did you get it?
They have.
It is in the record.
For the satisfaction.
This fellow was 28 years old. Even a child can't drown.
That conclusion, that one go cannot be wrong.
And your lordship indulges my lord.
जगह नहीं है. He can get trampled by a speeding vehicle. It's all road and I don't think there would be some collection of water somewhere. That must be used for cleaning himself.
Photos were taken on the road. That particular water body is.
No, where is that?
By the side of the road. That is the photograph. That is the photograph. She has taken.
This doesn't demonstrate either that he was killed. This is a false thing. I mean,
Ultimately, the finding of the.
it has to be taken very seriously, Mr. Nath. We are laughing not at the situation, we are laughing at the naivety of the persons who have done this. I mean, this is the report, and the magistrate says no foul play. What kind of an inquiry officer was he? Was he or she?
In fact, the medical reports, if lordship considers now. After that,
Medical report, suppose you say that this is there is a definite allegation of assault on head, and the post-mortem report would say that he has died because of the puncture of heart. Are we going to believe that?
no, page 40.
If that were so, then the doctor's opinion would be the final opinion.
Page 40.
Question is this: he drowns. You have not said anything that at the time of arrest he wanted to run away. Mild force was used. Did you say that?
No, we have not.
You have not said that. Therefore, the injuries can't be explained.
We have explained. In the affidavit, we have said that while he fell down and while the body was taken up, there may be some there may be some aberration.
This is how you save a drowning person.
No,
You beat him. You beat him, cause contusion on his head, and then you say that this was for saving him. Yeah, but therefore, we say it is ludicrous.
page 40.
Let us not get into
Page
the police officer will go to jail.
Page 48, stomach and the contents. If the person dies, then he is thrown out to the water. Then the water particle will not, no, water particle will not go to the stomach. that is the condition of a person who died drowning.
Are we, I mean, they are asking you, to state you don't have anything. आपको क्या पता? Confusion कैसे हो गया? Abridge हो एक रहता तो समझते. The entire body is full of confusion. This will not be acceptable. We'll discard everything. And we'll direct for institution of a criminal case against the officer in whose custody he was there.
But
Because we are not because we want to do it, but because we have no other option. This has to be discarded. This inquiry report is wrong. And in fact, I have a very poor impression of the judicial officer who has conducted this inquiry and given the report. It could have been done more intelligently.
I respectfully submit that on the basis of materials available on record and the medical reports, that inquiry report has been submitted. Here the petitioner,
What was
here the
then
petitioner-
the report should have been there. The postmortem report as a-
no, here the petitioner has come up with a prayer malab for investigation.
Where
Investigation
other
and
persons
compensation.
were arrested along with him. The two other persons also were arrested.
Yes, madam.
Two other persons, were they in the same vehicle?
No, madam.
What was their statement? What are you talking? These are the checks. And then you were supposed to go to Udalgiri. After he was drowned, he was taken to hospital. Did you go to Udalgiri to catch hold of two other persons whom he had named?
On that day, madam, because of this,
Because of this, yeah,
ultimately they could not.
Let us see the admission. He was taken to a hospital, no?
Yes.
For treatment. Or the police officer would not have declared him dead.
No, immediately.
So where is the hospital certification that he was brought under this condition or he was brought at dead?
The inquest report is there, madam. In fact, in the ambulance.
Inquest has taken place now. Where is the inquest report?
It is
a police officer inquest here.
it is
Then, Mr. Nath, after you have he drowned, then you
Yeah,
took him to the hospital.
Puranan.
Where is that initial entry that he was admitted? Then he was brought there.
Or he was
then it was
dead. Where is the MLC, medical legal certificate by the hospital where he was first brought?
Madam, the report I have given, madam. Well, the report I have given, there the inquest is also available.
It is fine.
In the ambulance, madam, it was done in the ambulance.
While bringing him back to the hospital.
He was taken to hospital. There inquest was done.
Which was those medical things that he was. To which hospital he was taken?
Tolaram Bhakna, madam.
Tolaram Bhakna. Which was the Tolaram Bhakna's record?
Yes, sir.
They are supposed to go to Udalguri.
Yes. At North
Then
Guwahati.
how they reach this place?
No, from North Guwahati they were going. North Guwahati incident took place. From North Guwahati to Tolaram Bhakna he was taken.
From North Guwahati to?
Tolaram Bhakna.
No, I'm not saying. He was arrested from where?
He was arrested in North Lokhimpur.
Then
He was brought to kept in North Guwahati police station. From North Guwahati he was taken to Udalguri. While in that particular North Guwahati the incident took place. From North Guwahati he was taken to Tolaram Bhakna, that is the nearest hospital.
Now this inquest was done by whom?
I have the executive magistrate.
Executive magistrate.
Lordship.
Now come to section 176. Of the CRPC.
Lordship.
Before amendment, 1973 CRPC. Read provision of 176. In fact, FIR should have been registered against police officer. Entire. It calls for a very serious trial.
But
Better option for you is to pay compensation and get your hands on. If we hear this matter, we will direct for institution of a regular case if it has not been done. Then I think there is no way out. They have to be tried after investigation. We have all the case laws on the subject. This can't be tolerated and kill him. At least it requires a trial. They want compensation, give compensation and be happy with that.
Custody, not custody.
Consider and we'll hear you again. Act wisely. Or wait for a better bench, I don't know.
No.
I don't know. Act wisely. Don't let your officer, don't let the state fall in disrepute.
In fact, my Lordship, there is a decision of this honorable court.
Stated to any rational person, your report of the judicial officer shall be thrown in the dustbin. It's not worth accepting.
But
Prima facie, apparently, it is a piece of lie.
Mr. Nath, have your instruction.
But I have a submission. But in fact, there is a decision of this honorable court where the person was committed suicide in the lockup. Since the person was in the custody of the authority, compensation has been directed to be paid. Following that principle, my lord, here also the person was in custody. If lordship directs compensation,
We will not direct. You tell us.
If we direct, we'll direct not only one thing.
How can we direct compensation? We'll have to direct for a criminal case to be instituted against the entire police team,
in
which
fact,
had gone to arrest. Have you lost a case?
but in fact, FIR has been
The
lost. on both
superintendent of
sides.
police should have lost a case against him,
FIR has
against the
been lost.
entire team, including the driver, because they'll be witnesses.
Two cases have been registered. Lord.
Unnatural death case, UD case was registered. We are not asking that. In case of such deaths in police custody, the FIR has to be lodged against police officers. We will direct. If you want us to direct for compensation, we will direct for trial. I mean, FIR and investigation.
But
The reports are very, very incriminating. I mean, I don't know how you are not looking at it. We find it totally incriminating. Show it before anybody, they will say this. Get out of this gridlock. Therefore, we have used very, reconsidered expression, act wisely. We are not asking, we can't issue direction for payment of compensation. If we do that, necessarily we'll have to put you to, put all the entire police team to prosecution. Then only.
no, even if since the person.
Don't argue further. Take a call. We are giving you 8 weeks time.
Lordship.
You might get a better.
No, I am not on that.
We are keeping it in August. We are keeping it in August. See, the case laws are against you. The prima facie evidence is against you. At least you would agree that even if we take a very, very sympathetic view, very liberal view, so far as the state is concerned, we'll have to direct for lodging of the FIR against the entire police team. Because if you want us to record, we will record that this report by the inquiry report by the judicial officer is a piece of lie. We can use that. That's a bad report. And we can say that. I mean, there are better ways of coming out of that problem. Not this. Up till now, we will also have to inquire who was the superintendent of police that time, why did he not take the action, why FIR was not registered, notwithstanding the filing of this case. FIR should have been registered, no? Against the entire police team which had gone to arrest him. The needle of suspicion goes to them. I don't know, don't you read West Bengal versus Saha and other cases?
I see.
You'll get 5 cases. Haven't you heard of that Dudhnath Yadav's case? You have not. Please go to your portal and find out what is that. SCC Dudhnath Yadav, State of Bihar versus Dudhnath Yadav. You'll find my name as lawyer.
I'll see. I'll go.
Argued by all top lawyers of the country. I was only an assisting counsel. That was a case where a businessman was killed in the jungles of Barachatti on way to Gaya. This businessman had purchased saris to be sold in Ranchi. The purchase was made at Varanasi. There were telephone calls from him to his wife at Ranchi that I'll be reaching early in the morning, prepare good breakfast for me. In the meantime, he crossed through Barachatti. Barachatti is a place somewhere near Gaya, outskirts of Gaya. Gaya is a town in the state of Bihar. It's a jungle. One police officer, I don't know what, asked him, may have asked him for some money to be paid because he was a sitting duck, a businessman with lot many purchased commodities in his car, Maruti van. And he was shot at point blank. And a case was lost by the police that police sniffed something. And when he was asked to stop, he sped the vehicle and started firing. There were criminals on the vehicle. And because of the firing, we had to counter fire. And in the process, one person was killed, others fled away. And they got seized, they got recovered cartridges, used cartridges, and weapons also. And ultimately, inquiry took place, and both the cases were found. It was found to be a false case. It was a point blank murder. And during the course of inquiries, the officer who was indicted and who was charged, who was sentenced to death, he got a prize he got a police medal for apprehending and stopping some kind of onslaught somewhere in Ranchi. Other members of the police team thought that they must also enter the fray. So those were the persons who were on leave, but they also said before the superintendent of police and the DIG that we were also there in the team. We have not got any award. They were also made accused in that case on their request to be given an award. And all 6 were sentenced to death in a regular trial by court. And I had appeared for that police officer who was being defended by, his case was being handled by his son, a student. And ultimately it was found that he had used his service revolver to kill him because he had not paid up 50,000 rupees. He's still lying in jail. The death sentence was commuted into life.
I'll go through.
It's not an easy thing to handle. Custodial death is one of the most dangerous things. And you don't have any sympathy. Equal responsibility of all, unless your actions are evident. Act wisely, therefore we advise you.
No.
We are giving you 8 weeks.
No.
As prayed for on behalf of the state. Let this matter come under consideration on. Give a date.
12 August. 12 August. No.
Just a minute.
26 August. 26 August. 26 August.
Do something positive. Let Mr. Patawari not press this petition. All right?
Not right.
We don't say any